Joining us first on Left, Right and Centre tonight to talk to us about the implications of what has happened in court today is one of the leading petitioners in the case, Arun Shourie. Mr. Shourie, thanks for joining us tonight. How important is this, what the Supreme Court has said? And I'm asking you to wear two hats today. One is, of course, as a former editor. You've been an editor during the emergency. You know how important freedom of the press is. From the press's point of view and also politically, how is this order significant today?
I think it's a very, very important order because, as you know, the Supreme Court of India has been one of the great courts in the world in regard to the freedom of speech. They have always preserved it. And in this case also, that's what they have done. And in fact, therefore, it's very important for our petition that they will hear it on merits. And it's very gracious of them that they will hear it not in chambers, decide among themselves, but they will hear it in open court. Secondly, it is very important for enforcing accountability in public life, and thereby enabling, and for doing that, to enable the media to do its job. The government had claimed privilege. They say the documents are in public domain. Where is the question of privilege? Official Secrets Act. In fact, the Attorney General had gone so far as to threaten in open court that we will proceed against the journalist, we will proceed against the paper, we will proceed against the advocate, we will proceed against the petitioners. He had said this. I was astonished. He is such a senior person and has, I am sure, argued cases of free speech. But he said this, and the court has completely disregarded and brushed that aside and said that no, these questions of privilege do not arise, official secrets doesn't arise, and none of these things can be a cover for wrongdoing. But that's the judgment of Justice Gogoi and Justice Kaul, and they cite the cases from Ramesh Thapar's case onwards till Pentagon Papers and others which we
in
had
fact, yes, they
submitted.
cited the Pentagon Papers and
yes,
and
Prashant had drawn special attention to that. But second, I think, if I may just, Nidhi, one point, Justice Joseph's judgment says I concur with that and goes much further, because he says that since 2012, the Indian Parliament has brought about a complete revolution in regard to public discourse and public accountability of governments. That under the Right to Information Act, even those organizations which are exempted from the Act, intelligence
like
agencies, RAW and all, but if there is an allegation of corruption, a charge of corruption which is well documented, or a violation of human rights, as let us say in Kashmir, then in regard to them, documents have to, even in regard to those organizations, documents have to be brought into the public domain.
What is also important about these documents, Mr. Shourie, is that no one, and that's something the court order also talks about, the judges have talked about that today, is that no one really from the government side disputed their authenticity. It was more about, well, they were stolen, that later became they were photocopied. And you have actually said that by actually saying that these documents were stolen, the Attorney General is only confirming that they're genuine.
Actually, he did a great service to all of us by saying they are stolen and that's why we'll do this, that and the other. That itself proved that they were genuine. And in a series of judgments of the Supreme Court in the past, the court has held it does not matter how the evidence has been procured, but if it is genuine, which the Attorney General proved it was genuine, and second, if it is relevant, then we will consider it. And therefore, in the three judges have confirmed the earlier judgments of the court in this regard.
One of the other important arguments you've made is that, the government's assertions that the documents should not be examined because this is a matter that's related to defense procurement. And what you have said is that because they relate to such a vital issue such as defense, they need to be examined. And
yes,
that is where you think the court also finally sort of veered around to that.
That's a wonderful thing. That's a wonderful, very important point. Because the Attorney General had kept arguing, oh, this relates to defense. So 2 points on that. Firstly, defense was being used in a very loose way. I mean, land acquisition, let us say some defense land is given away in one place in West Bengal for collateral considerations to a builder. You can say, oh, defense. So the game was given away by the affidavit filed by the Defense Secretary in this very hearing. He said these people are giving up giving away the war capacity of combat aircraft. But there was not one document, there was not one submission of ours which had anything to do with the war capacity of the combat aircraft. If I say that this
sovereign guarantee is not there,
sovereign guarantee is not there, or offset clauses have been changed retrospectively,
or the PMO intervened, or whatever,
or PMO, there were parallel negotiations, or that you had these, I mean, all sorts of things that were done. The corruption clause was removed. How does that give away anything about the war capacity of the combat aircraft? And I think the court saw the merit of that argument of using this point about defense loosely. And secondly, as you implied, precisely because it deals with defense, and therefore the lives of our security men and the security of the country, you must examine the evidence.
What the Ministry of Defense today has said, though, in a statement is that it said that some documents just couldn't have been placed in public domain, but that these documents that are being presented are being done so selectively and presenting an incomplete picture. What would you say?
Nidhi, the best way is for them to please give the full documents to the court, then they will not be selective. And they have not said what is the other document. Is there another document which says that retrospectively the offset clauses were not amended?
Or that
is there a document to that effect? Or that there were not parallel negotiations going on? Or that the Defense Secretary did not write on file that the position of the Indian negotiating team has been seriously weakened, his words, by parallel negotiations going on from the Prime Minister's office? Or that the National Security Advisor, without any authority in law, had gone and made commitments and accepted terms which he was not allowed to do? Show us the complete documents on that. So you can't say selectively and just think that everybody will just swallow and vomit what you say.
Do you think that this whole notion of stolen documents, which then got changed to photocopied documents subsequently by the Attorney General, and this threat to invoke the Official Secrets Act, do you think this all came as somewhat of an afterthought to the government in this entire argument?
And
why so?
Because Nidhi, it's a very important point. That's a very good point. These documents were being published from November. One of the documents was in our petition. In a petition which we had given, it was annexed. Then the Wire, Caravan, they started publishing in the middle of December. NRAM started publishing his stories on the 19th of January. And it is in the Defense Secretary's affidavit, it was said, oh, such secrets are being given, combat aircraft and all this. And that we have instituted an inquiry when? On 28th of March. On his affidavit he says.
So the Attorney General made this comment on the 6th of March in court.
But 6th of March.
Yeah.
And the interesting point there is that if you were so concerned about secrets going on and you are sitting and waiting till the 28th of March for the investigation to be started, that was just an afterthought. So I think what government just could not answer on facts. So they tried to put a hurdle right in the beginning. And the substance of the matter is that that first hurdle has been crossed, and the Supreme Court has graciously agreed to hear the petition, our petition on merits. And if I may say so, there are two petitions that are related. One of them is
the review of the order itself.
Yeah. Because you have been, not because the court is wrong or something, but because you have been too trusting of the government, what the government submitted to you. You just took that at face value, and we have shown how that led to various errors. And secondly, that because the government did this deliberately, because it was not just one grammatical misconstruction, it is a series of things which they misled the court on, and a series of facts which they hid from the court. For instance, the meeting, they said all the processes are finished, let's say on the 21st of August in a particular year. But there was a subsequent meeting of the Cabinet Committee on Security on the 23rd of September, in which 9 changes were made which were kept from the court.
So that's what these two review petitions are now.
Therefore, we have said one is, therefore, review your judgment because you were misled. But secondly, because they misled you, you have to bring them and consider them for perjury.
Can I ask you a political question finally, Mr. Shourie, which is that, how do you see this playing out politically? We're going to start voting tomorrow in the general election. There are many political pundits who believe that as an election issue, Rafale has not had the kind of resonance among people, let's say Bofors did at that time. Do you think that politically this will have any impact on the BJP or Mr. Modi's campaign?
I think that as candidates get announced, then micro issues become more important. But as far as Bofors and Rafale and corruption and the emergency and all, I can tell you from the time of the emergency, I was told, all this business that you people are talking about is only drawing room gossip here. It's not with the people till the election results came. At the time of Bofors, we were told the same thing. Except when Jaswant Singh wrote from his village, I used to request him to write, he was my good friend, please write a column. What is the talk in your village? He wrote a sentence saying that they are saying, isne to top khane se chori ki hai. It is an area from which there is a great recruitment of the forces. I then saw that the issue has reached the villages. So I think there are too many constructions about Rafale. Elections will be decided by people on a host of issues. And in Rafale, and in all the other scams which are coming out, Nirav Modi's and all these fellows, and I mean, you can recount many more of these. In all of them, the central message that goes is that this claim that this is an incorruptible government, uncorrupted, untainted, that has been affected. So not Rafale as an issue in itself,
but a whole host of things brought together.
All of which none of which has been refuted.
All right. Well, Mr. Shourie, thank you so much for coming in today and giving us your perspective as one of, as I said, the key petitioners in this case. We don't yet know when the Supreme Court will actually take this up, but there is no timeline to this. It's clearly an issue that has been brought back to life, which perhaps the BJP had hoped would by now certainly be a dead issue. Thank you, Mr. Shourie, for joining us.